Welcome back! Today's explainer is diving into a seriously fascinating legal mystery: how a routine 1993 police raid ultimately dismantled a decades-old censorship law in South Africa. We're going to look closely at a landmark constitutional court judgment to see exactly how free speech is defined and how courts balance public morality against individual rights. Okay, let's dive into this. First, we'll cover the Santon raids, then the obscenity laws, free speech limits, the right to receive, the problem of overbreadth, and finally, the verdict. First up, the Santon raids are inciting incident. You know, every massive constitutional challenge has to start with a concrete event, right? For this case, that was February 1st, 1993. Police raided the Santon residence of Patrick and Inga Case. But they weren't looking for weapons or anything like that. They were actually looking for specific media that was outlawed at the time. The couple ended up being charged under the Indecent or Obscene Photographic Matter Act of 1967. So what did they find? Well, during this raid, the police seized exactly 150 video cassettes, and these cassettes contained sexually explicit material. Now, around the exact same time, in a totally parallel operation, another individual named Stephen Roy Curtis was caught with 5 similar cassettes in a shopping center parking lot. These might seem like pretty straightforward arrests just for possessing prohibited tapes, but they actually set the stage for a massive legal showdown because the applicants decided to challenge the very constitutionality of the law they were charged under. Let's move to Section 2 and see how this builds: the obscenity laws and a history of censorship. To really grasp why those 150 tapes were illegal in the first place, we gotta zoom out a bit. The 1967 Act didn't just appear out of thin air. It traces all the way back to the 1956 Cronje Commission report on undesirable literature. That report laid the foundation for the 1963 Act and eventually the 1967 Act that our applicants were charged under. And the intent behind this legislation was incredibly explicit. During the second reading of the 1967 bill, the Minister of Justice stated the law was designed, and I quote, "to protect a Christian, civilized country such as the one in which we are living." It's clear this legislation was built to impose a highly specific, very strict moral framework on the entire population. But here is where the legal mechanics get, honestly, really tricky. The 1967 Act didn't actually provide a precise definition of what indecent or obscene meant. Instead, it just threw out this remarkably broad, open-ended list. It banned photographic matter depicting sexual intercourse, sure, but also super vague concepts like licentiousness and lust, alongside homosexuality and even violent acts like sexual assault. It was literally a giant net, deliberately cast to catch as much as possible, which left the courts to enforce it on a totally ad hoc basis. Which brings us to Part 3, free speech limits and the global context. Now, with the dawn of a new democratic South Africa, this incredibly broad law suddenly had to survive under a brand new constitution. So the pivotal question became, does Section 15, which is the guarantee of free speech, actually protect sexually explicit materials? To answer this, Judge Mokgoro looked at how other democracies handle this exact same friction. The court basically synthesized 2 major global approaches. In the US, under something called the Miller test, if material is legally deemed obscene, it forfeits constitutional protection entirely. It's seen as having 0 social value. Canada, on the other hand, takes a different route, focusing on the Harn principle via the Butler case. They don't restrict material just because it offends community morals, they only do it if it creates a substantial risk of harm, like degrading individuals. The South African court used these international touchpoints to help navigate their own law. All right, moving on to Section 4, the right to receive and expanding the definition. So the crucial point here is a really fascinating realization about how freedom of expression actually works in practice. We usually just think of free speech solely as the right of a speaker to, well, speak. But the court highlighted that it inherently includes the audience's right to receive, hold, and consume those expressions. Basically, if the law deprives a willing listener, it's violating the rights of both parties. Judge Mokgoro put this beautifully in the judgment. She wrote, "My freedom of expression is impoverished indeed if it does not embrace also my right to receive expressions transmitted by others." She linked this right not just to a marketplace of ideas, but to the very foundation of autonomous self-development. The idea is you literally cannot realize your full potential as a human being if the state just arbitrarily cuts off your access to information, art, or expression. This leads us to Section 5, the problem of overbreadth and the unintended consequences. Now, this is exactly where abstract legal theory turns into a tangible, real-world threat. To strike down the law, the court relied on the concept of overbreadth, which is when a law's net sweeps so widely that it unconstitutionally bans protected rights while trying to hit a legitimate target. And get this, the state's own lawyer actually conceded this point. They admitted the 1967 Act was essentially a loaded shotgun meant to just hit absolutely everything in its path. And this brilliantly illustrates the danger of that shotgun approach to lawmaking. Because the law used incredibly wide words like manifesting lust, Judge Mokgoro pointed out what else accidentally became completely illegal. A television documentary about safe sex and HIV? Banned. Cinematic versions of classic plays? Illegal. An illustrated public service brochure dealing with sexual assault? Criminalized as a depiction of rape. Even a photograph of a tender embrace between a same-sex couple was caught in this sweeping net. It accidentally banned vast amounts of unquestionably vital protected speech. Which brings us to our final section, the final verdict, dismantling the law. So we've reached the climax of the case. Could the Constitutional Court actually save this flawed law? Usually, courts try to salvage legislation using steps like the Canadian Schachter criteria. Basically, they ask, can we just cross out the bad words, a process called severance, so the law only applies to unprotected speech? But to do that, the fix can't be a massive intrusion into the legislature's domain or budget. Well, the final verdict was that the 1967 Act was just too structurally flawed to save. Judge Mokgoro concluded that the overbreadth was so massive, you couldn't just take a blue pencil and cross out a few bad words. To actually fix it, the court would have to effectively rewrite the entire law from scratch and invent countless exceptions for art and science. And of course, rewriting laws is the job of the legislature, not the judiciary. Therefore, the sweeping prohibition was declared completely unconstitutional. This was a landmark, foundational win for the right to receive information and freedom of expression. Which leaves us with this final, incredibly relevant question. How can a society balance protecting public interests without accidentally silencing vital cultural and educational voices? When laws are written like loaded shotguns, it's almost always marginalized voices, educators, and artists who get caught in the crossfire. It is a powerful reminder of just how fragile free speech can be and why precise, careful lawmaking is absolutely essential. Thank you so much for joining me to unpack this explainer. Keep learning, keep questioning, and I'll catch you next time.